friends who are here, and hello to the ones who are joining us online. So, yesterday we ended our discussing administrative law, and we also saw the high yield areas where the questions are being asked, right, and we left just before DICE, right, and I said that we will be covering DICE in the next session. So, DICE is a very important figure, especially when we look at the administrative law, because essentially it was the contribution regarding the idea of rule of law that defined its significance. You see, we have to be very careful when we talk about rule of law. It is not something that originated in modern times or when DICE was actually working. The idea of rule of law can be traced back to time immemorial, including Aristotle, Kautilya, and whatnot. Okay? That the law should be supreme. So, the doctrines of rex lex or lex rex, etc. have been there, right, and this idea has been fiddled with before as well. But to credit of DICE, he brought the idea to the fore again and provided its interpretation in the modern times. And that is one of the most significant contributions of DICE. Like I said, that everything should happen as per law, that law should govern rather than any single citizen. So, even if you look at Arthashastra, the king has been called as a constitutional slave. Okay? The king was called as a constitutional slave. Okay? So, the idea is fairly old, but its modern interpretations is what is significant. Okay? So, A.V. DICE actually stated that the supreme characteristics of the English legal system was the rule of law. So, he placed rule of law at the core of the English system, and largely if you see, yesterday we were talking about the American interpretation, the British. In India we would largely coincide with the British one for the fact that we have been colonized by the British for quite many years. Also, the idea that the British interpretation seems to be more wider. Okay. So, rule of law is not a single idea. Yes, it is a combination of ideas that have been given a single title. Okay. It has a number of sub ideas associated with it. Those be equality in the eye of the law, that irrespective of caste, creed, position, wealth, law has to be obeyed by all. Also, nobody shall be detained unless the guilt has been established. And this gives rise to, things like habeas corpus. Okay? Then the idea is that the rule of the constitution. Okay? With regards to the constitutional law, often the idea of rule of law, or by extension administrative law, that what is more constitutional. So, there was this PYQ that the administrative law is more constitutional than the constitutional law itself. So, this comparison is again very, very vital. It says that the rights which are given in the constitution, to think that the constitution is the source of right is not a very clear orientation. Rather, it is that very rights that gave rise to the constitution. Okay? So, it means that fundamental rights, for example, right to equality, right to freedom, they do not look much into the constitution rules as the top courts of law. And therefore, it places the judicial system to protect those rights. Also, it means that the people should not take law into their own hands. The appeal should be made through constitutional and legal channels, whether through courts or through public representatives. So, there is a democratic element which is there. Okay? Also, the law should be a deliberative outcome. It should come after discussions. Okay? You see, with response to droit administratif in France, Dicey believed that the system of separate courts that had developed in France as part of the droit administratif was a means. So, Dicey was criticizing the droit administratif in the sense that it was a means to perpetuate injustice. It was something that was putting the rights of the citizens in jeopardy and violated the right or the rules of equality. Okay? So, in this sense, the Dicey's vision is a far more universal, far more egalitarian vision. So, I want to draw the attention of you all on Dicey through those PYQs. Like we said that the journey of administrative law, and this was in 2018, has moved much beyond A.V. Dicey comment. So, we will have to think of the ways that the cardinal principles of administrative law, how they are getting metamorphosed in the present times. For example, the liberal interpretation of rights by the Supreme Court in India. Okay. Right to be forgotten debate which was there in the news, privacy rights, so on and so forth. And that is how we will have to show that, okay, this was the administrative law which we see through the lens of Dicey. It had these 4 or 5 major postulates, and with the advent of time, how this ambit has got broadened. Herein you can use the standard paradigms either by Henry or by Golembowski, or our general approach from SMT to CMT to NPA, so on and so forth. Okay. But it is important that we lay stress on that aspect, just the example that I gave you. Okay. So, this was basically the idea related to Dicey, but we will have to understand that Dicey himself has not been beyond criticism. Dicey has been criticized. You see, law is an entity which is not alive by itself. How men take law, how men use law actually defines its character. Okay. So while the equality aspect which is there in rule of law, administrative law, as highlighted by Dicey, it is there as a principle. But is that principle effective, or can you actually play with that principle? This is the moot question. Because a rich person will be able to hire a battery of lawyers, while a poor person cannot afford it. You saw how stuff happened in Pune. A rich lad's car actually mowed down two people on a motorcycle, and the whole system was behind it. You go and try and pick a pocket. You might be behind bars for years altogether for that. You might not even get a case hearing. Forget about, going into the merits of the case. Okay. So, what is this equality in the eye of law? When we see the equity part of the law, even if we see the equity part of the law, we'll have to go into the ethical standards of the bourgeois class and the proletariat. The one who has power actually ends up exploiting the powerless. The law as a statutory idea seeks to actually protect the interest of those very lawmakers, which get reflected in the societal reality. So, administrative law relation to the society. Who are these politicians, public representatives, people who command resources, make decisions? They are largely the people of upper classes. Okay. In a country like India, where complex social stratifications exist, yes, in certain parts, castes as well, religions as well, ethnicities as well. Okay. So these are upper classes. So the equality in the eye of law is nothing but a legal counterpart of laissez-faire. So this is your first question to be done as homework. That equality in the eye of law may be seen as the legal counterpart of laissez-faire. Critically analyze. The habeas corpus actually secures the liberty of the individual as long as in the eye of the law that person has not violated the law. Otherwise, detentions are held legal. There are clauses in law, for example, preventive detention, etc. Okay. So the administrative law as it existed as part of the droit administratif, and how Dicey criticized it. These criticisms, though on paper might seem valid, but in reality they do not operate. Also, when we see the idea of rule of law vis-a-vis the emergence of the welfare state, wherein the state is aggressively moving and growing in the social and economic activities, it has necessitated by this very expansion of the roles of the public administration to vest that sort of a discretion in these administrative entities. These administrative entities will now have to be empowered with far more level of discretion because of the growth in role and functions. Okay. So, the amount of discretion, power which an administrator have in the era of welfare state has been unlimited. Why? Because they have to fulfill the societal needs because of the legislative policies, and there is an element of trial and error. Also, while Dicey was of the view that there was no administrative law that operates in England, but his critics argue that there has always been a body of law that was applicable to administrative bodies. For example, the Crown Proceedings Act, etc., etc. The immunities which are given to, let us say, diplomatic agents. Though the Britain has democracy, it's a constitutional monarchy, and that is an unwritten constitution. So, the monarchy, the family enjoys a special status and they have their own prerogatives. The monarch cannot be sued. His critics argue that the Droit Administratif, and why am I emphasizing on Droit Administratif again? Because that actually presents a parallel narrative. Also the differences, the similarities, the criticism of Droit Administratif and the idea of rule of law as given by Dicey, part of the larger framework of administrative law. The contextualization is important. So, his critics argue that the system of jurisprudence as part of the Droit Administratif actually gave a very specific protection to the citizens against the arbitrary action of the government more than the common law system. Okay? Especially a case can be seen after the First World War when the economic hardships were there. The administrative courts as part of the Droit Administratif system in France refused to accommodate the concerns of the bureaucracy and the mighty in order to provide relief to the citizens with regards to contracts, etc., etc. So, this idea of Dicey that the one who are governed and the one who governs are equal is a myth. There will always be inequalities. There will always be inequalities. But these inequalities should be based on principles rather than arbitrariness. These inequalities should be of either function or service, but not arbitrary in terms of status and privileges. Okay. So, this actually deals with the Dicey part, not the Dicey part, but the part related to A.V. Dicey. Next, we move on to the delegated legislation. And with regards to delegated legislation, I would infer or rather I would invoke the PYQs on the aspects of delegated legislation which have been questioned. So, there have been questions which are statement based. For example, the principle of delegated legislation is, I think, but I were to emphasize that it is well for Parliament to keep a watchful and even zealous eye on all stages. Herbert Morrison, analyze. So, this question at the core is about risk of delegated legislation if it is unsupervised, because there is a letter and spirit part of any law, right. So, while things might be followed in letter as part of the delegated legislation, but the spirit might be diluted for the sake of administrative convenience, that will also compromise with the legislative intent of that particular law. Next is something which was asked in 2019. Delegated legislation has become a strategic tool in the hands of the executive despite its utility. Strategic tools, that means arm twisting or using of delegated legislation as a tool by executive. Again, it is the risk factor, but a particular risk factor under the scanner. Okay. The recent question was asked in 2023. Subordinate legislation has its drawback. Subordinate legislation is delegated legislation. It does not negate the fact that it is also beneficial. So, again, risk, but along with benefits. So, the basic idea should be, which we should be studying, what is delegated legislation, risks, benefits, and how to minimize them. That will already entail a way forward. So, a simple topic which you can probably do in half an hour, right, and if it comes in the exam, then 10-15 marker, howsoever it comes, can be handled very easily. Like I said, remember the criticisms and the part, they will help you in analysis. Also, remember the examples associated with delegated legislation. Okay. I will come to the question, because once there was this subordinate legislation, that why is delegated legislation is a subordinate legislation. Okay. You see, law making is the responsibility of the legislator, okay, but the sheer volume, the complex nature of functions which are performed by the government, even the legislative business becomes a burdensome task, and hence the legislature delegates a lot of the power to the executive to add to the fine print. Now, when this delegation happens, the administrative authorities as part of the executive or the extension of the executive, howsoever you may put it, Okay. Exercise these powers by making rules and regulations in accordance with the provisions of the law. So, this particular exercise of legislative power by the executive is termed as delegated legislation. What are these? These are administrative entities, departments of the government. Remember, it is not the conferring of the law making power. It only supplements the law made by the legislature. But that is a major work of the administrative agencies. Okay? We are, as it said, that we are far more governed by the rules and regulations than by the laws. It is these rules and regulations which are made regarding a policy, gives an expanded orientation to the policy, gives it the concrete shape. Now you see the delegated legislation, and please be very clear that the exam can trick you on this, is known by several names, such as administrative law is almost equated with the idea of delegated legislation. Administrative law or rule making, administrative law making or administrative rule making, administrative legislation, subordinate legislation or quasi legislation. Okay? So, that is there. Now, there are slight differences. For example, in UK, the delegated legislation includes rules, regulations, orders, warrants and minutes. In US, the terms rules, regulations, instructions, general orders, circulars, bulletins, notice, memorandas, they are used. In the case of India, the power of delegated legislation at the administrative levels are granted either by the union or the state governments to departments or regulatory bodies and other agencies. You know, you would have heard that TRAI will frame detailed rules in this regard, or to local bodies, or to statutory corporations, or even to universities or professional bodies, FICCI to provide rules related it, things like that. Okay? You see, whenever the delegated legislation happens and a power is delegated to a subordinate authority, it cannot further subdelegate it. Please understand. Now it becomes the sole preserve of that entity, whether department, regulatory body, etc., to fill in the details which they have been asked to fill. Okay. Now, a question is, why delegated legislation is a subordinate legislation? See, it is called so because it is subordinate to the main legislation that is enacted by the legislature. The Parliament or the Senate or the Assembly, whatsoever may be the case, will pass an act in general terms. And then the executive entities, a ministry, department, etc., will make the details. So, this authority which is conferred on the entity to make the details, entity would mean here again I would like to clarify, department, regulatory body, etc., the ministry concerned, is not the original power of the ministry or that body. It is something that has been conferred upon it by virtue of delegated legislation. It is not the original power. Okay? So therefore, the delegated legislation is subordinate in nature to the main legislation. If there is any rule which is not in keeping with the spirit of the original statute, it can be rendered as void. Delegated legislation is also subjected to judicial review, especially with the idea that it conforms to the spirit of the main legislation, and it can be rendered infructuous by the court. So, any queries till here? Any queries, friends? Are you getting everything, friends watching online? Okay, let's move ahead. So, with regards to delegated legislation, and I am deliberately spending some considerable time on it for the reason that it gets asked very often in the examination. Now, often the exam can make you confuse between 2-3 things. Delegated legislation, executive legislation, administrative action. Okay? We must not confuse them. While delegated legislation would be about the laws made by the authorities under the legislature, to whom legislature delegates its legislative power, whereas executive legislation means that the laws made by the president and the governors under the articles of the constitution. It is not derived from the parliament. So, for example, ordinance would come under this category. Yes, they have a force of law, but remember a golden rule that a source of a delegated legislation will always be an act of parliament or state legislature or legislature in general for theoretical conceptual purposes. Whereas the source of an executive legislation is a constitutional provision. So, in countries like England, there are orders in council which do not actually form the part of the delegated legislation. They are the product of the original authority vested in the crown. Also, delegated legislation is different from other administrative acts or actions. For example, let us say issuing of licenses, inspections, raids, etc. Okay. It is an action which is taken by executive as per the statutes, rules already laid down under some legislation, either direct full legislation or delegated legislation. Okay. Now, why delegated legislations actually grew so much? Why there is an outgrowth, a rapid growth of delegated legislation? There must be reasons. One easy to understand reason would be, if I see this as the scope of public administration, it is widening. Okay. It is widening with the passage of time. The functions are getting more complex, the functions are getting more sophisticated, diversified, right, which is beyond the remit of the legislature to focus upon in great details. So, therefore, the legislatures end up making the skeletal and the details are left to be filled via delegated legislation by these agencies. Also, if we see the growth of delegated legislation, it has been, the pace has been far more in the developing world. Why? Because they face more challenges. Also, if we see that this pace is more because of the coming up and expansion and orientation and reorientation of the welfare state. Okay. So, broadly this should be the grounding idea that you should all keep in mind. Okay. Now, if you look at the delegated legislation, a welfare state is characterized by extensive legislative activity, and that actually engages the parliament or the legislature. So, please understand, if I am using the word parliament, it means legislature. So, that engages the legislature in a hyperactive mode, and therefore, it sketches the broad details and leaves the rest for the authorities because of the time and resource constraints. Okay. If you look at the sittings of the parliament, they have been increased. Yes, there are other factors, productivity, disturbances, ruckus, etc., but the sittings have increased, the average duration has increased. Also, you see, with a rapidly changing environment, especially socio-politico, technico and globalization space, you need a law which is flexible or quickly adjustable. Otherwise, your law will start lagging behind the reality, and you will have to frequently go to the legislature to change it, which the legislature will not be able to do rapidly. So, the delegated legislation actually allows that sort of flexibility, adjustment that can be made, okay, so that the local conditions, local needs can be satisfied. Also, this is in line with the bottom up idea, with the customization approach, okay, with the anti-development thesis. Okay. We saw how, let us say, the delegated part of the NDMA, National Disaster Management Authority, and the state disaster management authorities came in handy at the time of COVID-19. Everyday rules were changing. Why? Because they were to respond to the rapidly evolving situation. Otherwise, every time you would go to Parliament, that how can somebody impose a fine of 2000 rupees for not wearing a mask? Okay. And hence that is there. Also, with regards to civil services, it play a key role in delegated legislation. Why? Because it is the civil services, it is the administration which is at the cutting edge of the government. It interfaces with citizens, it takes the feedback to the top, and hence delegated legislation provides that sort of a flexibility. Also, like I said, that the matters are getting increasingly technical, increasingly complex. So, this scientific technical nature of the matter, the Parliament may not have the ability to make such laws, because it is a body of laymen, they are not specialists. Okay. Also, like I said, to deal with emergencies like wars, pandemics, economic crisis, you need to vest certain amount of discretion. While discussing administrative law, we talked about how certain amount of discretion has to be vested with the complex nature of functions. And a cumulative effect is coming because of these reasons, that the delegated legislation is being increasingly used. So, there was this committee. The committee was called Donogh-More Committee. It's DONOUGH. Donogh-More Committee on the ministerial powers in UK. Okay. It talked about that if the Parliament would not delegate the law making power, the Parliament will never be able to pass the kind of laws, the number of laws that it is able to pass. And hence, delegated legislation, write down this statement, delegated legislation is a phenomena of modern positive state. Okay, this is the statement and you have to comment. This is another homework for you. Because the modern legislatures are burdened by the sheer weight of the complex issues that they have to deal with, and thus the increased volume of delegated legislation. Okay. Also, like I said, not just the complexity of issues by virtue of technology, social mobilization, social movement, globalization, right, they need that such regulations be flexible. Okay. Also, you see, to respond to it, administration is a key entity and it needs that sort of an elbow room, that sort of a flexibility to respond to the challenges which are coming up. Okay. So, Lasky, Laski, actually state, and you can quote, there is everything to be said for and little effective to be said against the process of delegated legislation. So, he is a supporter of delegated legislation. Anyone who examines the kind of subject matter, anyone who examines the kind of subject matter with which it deals will find that it saves a good deal of valuable parliamentary time, which can be better used for other matters. Also, you see, the legislative burden is increasing, the legislative complexity is increasing, but the legislative functionality is also getting complex. You see, more legislatures are coming up. For example, here in India, we can see how in recent times more states have been created, especially if we look at past quarter of a century, 25 years or so. So many new states have come up. Also, with more demand for representation, increasing population, the number of seats in these legislatures are increasing. Yes, in India the census is yet to be conducted, but one of the reasons why which new parliament building was actually made was the fact that you need more space for legislators. Okay, and who knows that after delimitation the size will increase by some numbers. So, it is getting complex for legislatures to operate. Okay. Apart from the rapidly changing environment that is there. Also, there is a flip side to it. While the legislatures are the bodies of laymen, administrative entities are experts. We say, no, the bureaucracy offers technical expertise, etc., etc. Okay. So, you see that globally we have seen that the delegated legislations has increased. In the developing world, right, and in democracies, because of the widening functions of the welfarism or the widening ambit of the welfarism and the increased frequency of the legislative business, it has further aggravated. So, it is both a generalistic as well as a particularistic phenomena, the growth in numbers of the delegated legislation. Everywhere it is increasing on, whether US, UK, India, everywhere it is increasing. Right. बारिश की वजह से लेट हो गए, कोई बात नहीं. All right. Okay. Now, there is a typology of delegated legislation. I'll provide the typology for the fact that it provides you that conceptual depth. That's it. Okay. Have you read about the typology of delegated legislation? No? नहीं पढ़ा? नहीं पढ़ा है contingent legislation, supplementary legislation. पढ़ा? ठीक है. You see, there are multiple typologies exist. So if we look at the content and structure, or rather content, structure and purpose, not the structure but the purpose. So you have a contingent legislation. Okay. You see, as the name suggests, when the legislature actually provides for a delegated legislation in times of a contingency, when a contingency occurs. So it delegates the powers to act upon to the administrative agencies. For example, to give the power to a district magistrate to control a riot or a law and order situation, right? Under which rules you want to apply, preventive detention, things like that. Okay. Then there is a supplementary legislation, filling the gaps in the law, filling of the gaps in the law. So the legislature will provide the general principles and executive will fill the details. The executive will fill the details of it. So whenever the executive will allow such an action, there can be a risk that the actual spirit of the legislation may get trampled upon. Okay. So for example, if you see, you had 73rd and 74th Constitutional Amendment Acts, right? And then the model Panchayati Raj Acts and model Municipal Acts were passed. But they were the model acts. Every state government, you see, practically we have so many models of the local governments as many we have the states. And within states you will find differences. Similar is the case with the law and order administration. You see, while the commissionerate system was applicable in Noida and other parts for so many years, Lucknow has recently got the commissionerate system. Okay, so things like that. Why? Because these rules, when I said that there is a risk, the risk is that the legislature has conferred the legitimacy to the administrative authorities to frame the rules and fill the details. But these framing of rules is necessarily not going through the scrutiny, because the legislature for a purpose has delegated it, and it can trample upon the rights of the citizens, and like I said, can actually trample upon the spirit of the law itself. Next typology is interpretive. Delegated legislation. How the broader skeletal has been framed by the main legislative body, and the administrative authorities or agencies are providing their own interpretation, and then further guide the subordinate offices to actually follow that interpretation. Okay. So in India, these interpretations do not have a force of law, but in US it does. Okay. Next typology is based on impact. Impact. The first one is normal delegated legislation. You see, every legislation should be very careful to avoid any undue encroachment on the rights and liberties of the citizens. So it would be better that if in the main law the caveats are mentioned, the limitations of the delegated law are mentioned, so that the administrative agencies do not trample upon the rights and liberties of the citizens. For this, we have the courts to interpret, just in case those caveats are not mentioned and the rules and or the DL actually crosses its original remit and encroach upon the rights and liberties of the citizen. Then is the exceptional. Something wherein the executive will acquire abnormally exceptional powers. Okay. For example, in matters of taxation, generally the executive has the most powers. Okay. And it also confers wide degree of discretion. Right. This is something which is largely found in Britain, not in India, because in India the doctrine of judicial supremacy and the doctrine of checks and balances are held at a very high pedestal. Okay. I hope the advantages are clear, right, of delegated legislation. So is the disadvantage when we talk about the risks which are associated. Okay. Also, you can add generic aspects like what if the administration is corrupt? It will lead to corrupt legislation, but be smart enough to actually cloak it with the pavard language. Okay. Also, there can be political pressure vis-a-vis rule making. It can be made to serve the interest of the influential people. Okay. The flexibility which is present in the delegated law can be misused. When there is vagueness in the empowerment clause, it can again lead to misuse. Okay. Also, delegated legislation might lead to loosening of the popular democratic control over the lawmaking. The escape of scrutiny by the Parliament of delegated legislation is again a problem. Okay. People might not be well versed with the rules, but the administration, for its lapses, both errors of omission and commission, can take the shield of rules to actually go scot-free without being held accountable. Okay. Now, we have talked about risks, benefits, challenges, etc. We should also talk about safeguards. Safeguards. I have given two homeworks, okay, till now. So, have a look at them. So, friends watching us online, understood? You see, clearly there are more benefits than threats, but those threats have the capability to actually expand and can, trample the entire spirit of the law and constitution. Like I said, there should be limits which are built into the main law regarding the scope of the delegated legislation. Also, the careful objective definition of the powers. The courts can play a great role. So, in countries like India and US, so I am giving you a comparative perspective as well, where judicial review is there, it can happen. But in countries like UK, where the parliamentary supremacy is there is, in India, can you say, India will have the constitutional supremacy. But in UK you have the parliamentary supremacy. So, in UK they cannot be reviewed by the judiciary. So, in countries like UK, the parliament itself should act as a self-regulator. So, same, Donagmore committee actually also in UK talked about that all laws, rule of law and the principle of rule of law actually says that all laws, all regulations should be open to challenge in the courts, except for the fact when the parliament comes to a conclusion that it is necessary in public interest. Also, while making the delegated legislation by these very administrative agencies, they should not follow an inward orientation. They should follow a consultative, participatory orientation. A clear process of formulation, printing, creating awareness, publishing it, etc. should be established so that everybody can get sensitized. Also, there should be reasoning, explanatory notes which should be attached against each regulation. The parliamentary control should be strengthened either through committee system or through other mechanisms and devices available with the parliament. Okay. Also, you see, delegation is inevitable. It is not something that we can do away with delegated legislation. So, if you look at India, Articles 245 and 246 provide for the legislative power of delegated legislation. Okay. Also, in case of India, the rules of procedure, rules of business of the houses deal with the idea of delegated legislation. For example, Rule 70 provides that a bill involving proposals for the delegation of legislative power shall further be accompanied by a memorandum explaining such proposals and drawing attention to their scope and stating also whether they are of normal or exceptional character. Okay. The committee, there is a committee on delegated legislation as well, right, to examine that.
Like issuing certificates by a lower authority in the name of a higher authority is kind of.
No, it's not a delegated legislation first. While explaining delegated legislation, even an ordinance is not a delegated legislation, or rules framed in pursuance to an ordinance is not a delegated legislation, because that power is coming from a constitutional authority, not a legislature. So, the basic litmus test is that unless and until the legislature confers that power, it is not a delegated legislation. The basic concept is this. Okay, if a lower level or sub office is issuing a certificate, let us say in the name of the state or in the name of the government, it is because it has been empowered by a statute. So, that empowering by a statute, maybe because of some rules etc., is delegated legislation, but the act of granting that certificate is not delegated legislation. Okay. That is simply the function or the public service that it is performing.
Not a power.
No, it is a public service, it is a part of the function. Who can exercise that function? That authority is vested. For example, you go and register a marriage certificate, so you will go to an SDM court, so called court, or the SDM office. So, the SDM will issue that, but that is recognizable pan India or globally. That is something which is coming from the constitutional law itself, but the idea is that whether this act is an act of delegated legislation, no sir, it is not. Okay. Next, I want to again come to a very important topic, which is the administrative tribunals. Though not very exploited, but somewhat recently, that is in 2022, there was a conceptual question on this. And you are expected to write the answer for this. So, please take the polity part from the polity. We are here to discuss the administrative part. So, the question said, all tribunals are courts, but all courts are not tribunals. Explain. See, increasingly I see every year there is one such question, which is a sort of a tongue twister type. Okay, not from administrative law alone, but in general. Okay. So, keep an eye on such questions. They are fun, but they are difficult as well. So, that brings to the fore the idea of administrative adjudication. So, what we are dealing with it? We are dealing with questions which are quasi-judicial in nature. By whom? By administrative agencies or department or tribunals that have been set up for this purpose. Quasi-judicial would mean seemingly judicial, but not exactly judicial. And this explanation will have the answer to the question as well. Okay. So, whenever such an order which is coming from an administrative agency or a tribunal, it is not a judicial act, but an act of administrative adjudication. Democ. our very own Democ, actually sees administrative adjudication as the process by which administrative agencies, settle issues arising in the course of their work when legal rights are in question. Then LD White, actually you will find that, let me tell you about White's view of administrative adjudication. You will find that Democ's view is far more broader vis-a-vis White. White actually is viewing administrative adjudication as the investigation and setting up of a dispute, the investigation and settling of a dispute involving a private party on the basis of law and facts by an administrative agencies. You see, Democ is actually using the word issues, whereas White uses the word dispute. This means that the administrative adjudication is even possible which do not involve a dispute. Right, you understand, it's a wider connotation that I am trying to direct you towards. For example, you apply for a license, okay, and the authority, licensing authority has to decide, let's say it's a driving license or a liquor license or something. Okay, and the authority is actually deciding it in granting of the license. No dispute is there. But still, if it is not granted, you can question it. Or the act of granting the license itself is adjudication, because it is verifying the application, seeing that whether you are eligible, you fulfill the criteria. Right. So, the dispute will become later. Okay. Whereas White puts dispute as an essential feature or a precondition for the administrative adjudication. Also, administrative adjudication is different from an administrative action as well as different from a judicial action. Please understand, this is administrative adjudication. See, it has some features of the both, of the administrative action as well as the judicial action. However, just to quote a caveat, some critics say that that there is not much of a difference between adjudication which is done by agencies and the justice which is delivered by ordinary courts, because it is the administration which implements that decision. And that actually poses a risk on the outcomes of the administrative adjudication, and hence it should be provided the safeguards as it is there in legal action. So, it is neither a purely private action, but also not a judicial action as given by the court of law. Okay. Understood? Now, I want you to have these details. Wherein we distinguish between administrative adjudication and judicial process. You see, vis-a-vis administrative adjudication, there is no definite legal procedure or principle is underlying in determining or administering the justice. It is only guided by certain statutory standards of common good and public interest. Whereas a judicial process, there are definite legal principles which are involved. You know, this year so many Sanhitas came replacing the CRPC, IPC, etc., Evidence Act. So, even a recording of evidence or collection of evidence in a particular manner is considered valid in a court. Okay? There are legal counsels which are present. Also, you see that the agencies or entities which are in charge of administrative adjudication do not enjoy the same immunity in respect of their judicial functions. Now, I want to bring to your attention that there was a Tribunals Act which was passed a couple of years ago, which rationalized the number of tribunals, merged certain jurisdictions, provided certain jurisdictions to High Court, completely abolished the tribunals, etc., etc. And I want to draw your attention towards RTI. So, there was this 2019 amendment which actually brought RTI, the CIC, ICs, SICs within the executive, larger umbrella control, vis-a-vis the earlier one which was seemingly far more independent, where the status is almost equivalent to the judges of the courts. Now, the government's argument was that with regards to RTI, they lay below the courts in hierarchy or in the scheme of things. How can they be given equal status? The opposition was saying that we are trampling upon the autonomy and impartiality of them. But if you look at this act, it is also like an act of a quasi-judicial body, which in principle should not have the same immunity in respect of the judicial functions. So, through this, when you are asked to, if you are asked to justify, through this also you can justify it, it will provide that sort of a conceptual ground for you. Okay? Whereas, as part of the judicial process, the judges have the protection of immunity. You see, vis-a-vis administrative adjudication, the administrative agency in the scenario applies policy and enjoys a certain amount of discretion. Okay? It can use other sources than the evidence to actually arrive at a particular view, whereas the courts cannot go beyond the evidences presented in the court. So, in that sense it is rigid. Administrative adjudication is flexible. You would have seen that in the absence of evidence they are exonerating, not because the person is not guilty, in the absence of compelling evidence. because it cannot go out. There are so many corrupt politicians who are known Bahubalis, who are known criminals, but there is no evidence. मिर्जापुर 3 तो देख लिया होगा. अच्छा, ठीक है. So in that also you have seen how Bahubalis are actually reigning, in certain areas, and everybody knows everything, but they cannot go beyond with what is being produced in the courts. Okay. Also, you see, administrative adjudication favors the administrative policy. There can be a bias, administrative bias, whereas largely courts are expected to be free of those biases. In case of administrative adjudication, there can be delegation. A secretary may ask a director to take a call. The minister may ask the secretary or the deputy secretary to decide the dispute. Okay. Whereas a judge cannot say that let a registrar decide. The judge will have to take a call. In administrative adjudication, the decisions might not be given with reasoning. For example, there is a contract which is to be awarded for creation of the building of a hostel, right, in a university. So there are multiple tenders which are issued. Some tenders are passed. Other people are actually requesting the information in terms of that, okay, what is the problem, my quote was lower, this and that. So the competent authority might simply say that we have decided to go with this party X and your application stands rejected. That's fine. Whereas a court will have to be giving reasoned judgments. Okay. Also, please understand, administrative adjudication is different from regulatory decisions as well. The regulatory decisions of administrative authorities such as registration, authorization, licensing, etc. Because they are discharging an administrative function as a part of a larger public policy. The judicial function would entail deciding on the status of the applicants, which involves discretion. So this can be a very blurred line, please understand. In some countries it might be considered as administrative adjudication, in some countries it might be simply taken up as an administrative action. Just like we saw that how the delegated legislation is in a way proliferating, increasing, similar is the case with administrative adjudication. Okay. So I guess that is something that you can take it from there. While dealing with features of administrative adjudication, we have in a way covered its advantages and disadvantages. Now, if you look at the idea of administrative adjudication, it's a broader idea, like we said. Okay, one of the ideas that fall under it is administrative tribunals. Again the reasons are same. The functions have grown by many-fold. The complexity has grown. Litigations have increased. Okay, and therefore, the administrative tribunals started coming up to ease the burden of the regular courts to deal with the specialized character of the complaints with a view to provide justice. So, generally you will see that any administrative tribunal is a specific agency dealing with a specific dimension of governance, right, and have a right to adjudicate on certain specific issues and settle the disputes between the citizen and the administration. So, between the citizen and the administration. Now, whenever you are looking at justice as an essential duty of the state to provide and the citizen and administration interface idea, please remember with regards to justice, tribunals play a very important role. Okay? They are different from regular courts. Why? Because the traditional judicial system of the country, which we see in terms of, let us say, the lower courts, the Supreme Court, the High Court, etc., which have a general jurisdiction, the jurisdiction of administrative tribunals is very specific. They can attract any case. I mean, regular courts can attract and entertain any case from murder to a slap to a pickpocket, whereas administrative tribunals actually serve a very specialized purpose. Okay. Also, administrative tribunals interpret and applies the laws when the acts of public administration are questioned by the courts or other methods in formal suits. They do not follow the elaborative rules of procedures of regular court. So, largely we can see while the court applies the law in general, administrative tribunals apply the administrative law. Okay. So, this difference is something which is essential. Also, there is a misnomer. Misnomer is that whenever we hear the term administrative tribunals, we think that the decisions will necessarily be administrative, but you will find that in many cases they are of judicial character. They are of judicial character. Why? Because they have to examine the facts, decide the cases in an impartial manner without actually looking at the executive policy. So, they act in such situations like any court of law. Also, they are administrative because the reasons to bring them in the picture are administrative. So, it is a specialized character. They carry the members in the panel who have specialized knowledge in particular fields. Okay. The reasons are on the similar side, okay, as we have seen for delegated legislation and administrative adjudication. Okay. Now, let us look at the merits and demerits of administrative tribunals. merits, the system is dynamic, capable of addressing to complex needs, flexible, adaptable. They are in sync with the socio-economic life. Okay. They are, we can say, more plug and play with the welfareist approach with the present day socio-political reality than the regular courts. They are quick, provide easy justice, avoiding or helping avoid a large cost which might be need to be paid by the litigant in case of hiring lawyers, etc. The procedures are simple and can be easily understood by common citizens. There is scope for experimentation. They carry the technical expertise. Also the value based judgments in which public interest is emphasized. It is of informal nature, the proceedings are of informal character. So, a common man can also take part. The way the information is stored, the way, because largely the information will be stored in the official records on which an administrative tribunal will be taking a view, adjudicating that matter. So, it is far more secure vis-a-vis the original, vis-a-vis the regular courts, where it is easy to tamper with the information because the court can be given any view, presented any view. Here the questions are very surgical, administrative in nature. Okay. Now, of course, there are demerits. You see, the way the administrative courts operate or the way these administrative tribunals operate, isn't it negating the spirit of rule of law? It is more akin to the droit administratif system than the rule of law, because separate procedures etc. are being followed for administrative agencies which are party to the issues which are presented before these tribunals. There is no set procedure. So, you cannot say what is right and what is wrong vis-a-vis following of procedure. It is vague. So, you cannot actually judge the violations. No uniform code of procedure exists. It is said that these tribunals actually hold summary trials because there is no use of precedents etc. The question on the qualification of the members of the tribunal is again questionable. So, now what will be the safeguards? These challenges will present the safeguard that the person, the right people should be appointed. Okay. Why not we form a uniform procedure for administrative tribunals? Also, they do not provide reasons for their decisions, they should provide the reasons, right, things like that. So, I would request you all that whatever tribunal has been in news, have a study of it, what is good, what is bad about it. An isolated question on that tribunal can be there in paper 2, but in paper 1 you can use it as examples. Okay, both sides of view, what is good, what is bad about it, right. So basically this actually ends our discussion on administrative law, right. Next we will be moving towards public policy, but before that I want you all to flip through the pages and let me know if there are any concerns or doubts before we actually take a deep dive into the public policy aspect. It's an important unit. Okay. Some of you have asked me in the past, what should we study? The idea that any basic material is sufficient, because public policy, and we'll talk about it, how the nature of questions is changing. But if you want to acquire more theoretical knowledge, IGNOU material, and there's a book by Sapru on public policy. Okay, that is there. That's for a general knowledge. At this instant, while majority of you are into writing mains, so any new material is to be avoided. Rather, reinforce whatever you have already studied. Try and refine it as much as you can. Okay. Any doubts, friends watching us online? Also, there is a request that please start writing tests, right? Do not delay it forever, and please start attempting the exercises. The procedure to send those exercises are in the first session, because unless you write, it will never complete your learning. 2, unless you write, you will never know where you are getting it right and where you are getting it wrong. So you will never improve. Should I start? Any doubts or देखना है अभी और? Okay. So if I take up the unit of public policy, I am staring at somewhere between 20 to 25 marks in paper 1, but more so it is important for paper 2 as well. Okay. Apart from this also, the idea of public policy is basically an idea of public administration, because there is a policy view of public administration as well. Okay. And hence it is vital that we look at this unit very carefully. There are certain concepts which are there. Okay. Apart from that, there are models and theories. But most of the question you will see are either interpretive or application oriented. So there will be a lot of thinking game which will be needed, because otherwise what will happen if I ask a particular model and something in the context of that model, and generally what will be the context, either something positive or negative about that model, yahi hoga na, hai na? You end up writing the entire model. That is not my answer, that may be your notes. Okay. So please be very careful. Now let us have a survey of the PYQs so that you understand what is being asked. So 2016 there was this 10 marker. In public policy making, rationalism is the opposite of incrementalism. So this idea of rationalism and incrementalism actually relate to the models of public policy making, the rational model and the incremental model. Any? So the models and their critique. Please remember that there might be an explicit question on the model or anecdotal question on the model, just like this was. The rationalism is the opposite of incrementalism. So it is moving, taking up with a larger canvas the ideology behind those models. But essentially you will have to use those models to justify the demand of the question. Or the third point could be direct, anecdotal. The third point could be the indirect use of the models to justify a particular context. We will see how. The policy process is again a very important idea. The public policy without the active, of all the processes involved in public policy, implementation is of great importance. Examine impediments in policy implementation. So there is this policy process, or we call it as a policy cycle, right? There are various cycles available, but the broad strategy would be policy goal setting, policy planning, policy implementation, then policy evaluation. These are the broad stages. Okay. So for every stage you should know what is good, what is bad about it, where the linkages are going. 2018 again a 15 marker. A public policy without the active involvement of people in its formulation, implementation and evaluation is only a facade. How can this be corrected? So public policy linking to other concepts, for example democratic decentralization, participatory democracy, or I can link it with good governance, or I can link it with globalization, I can link it with privatization, I can link it with liberalization, I can link it with bureaucratization. You understand? So these kind of questions. So understand this trend. From 2016 to 2019, the trend was largely one question, either a 10 marker and a 15 marker. Okay. So 29 was maximum social gain in public policy making is an attractive goal which is rarely found in practice. Discuss. So more on the philosophical tones the question came. But see, come 2020, and there was this big surprise where the public policy was asked of 45 marks. Again, the focus on one stage. Has policy analysis become a major source of legitimization of status quo in political and social order? See how application and interpretation oriented this question has become. That since analysis are not throwing up any major improvement, it has become a source of status quo. Next again, models, 2020 only. Have political realities thwarted the move towards evidence-based policy making? So, another key point is the contemporary tones like evidence-based policy making, data-driven policy, चल रहा है ना काफी, डेटा ड्रिवन पॉलिसी, टेक ड्रिवन पॉलिसी. Okay, so these contemporary realities you will have to look at through the lens of the models. Now see, abstract question. This you can place in paper, unit 1 as well as this unit. See, this was also asked in 2020, 20 marker. Globalization has impacted the context of national policy making. The national policy agenda is becoming international. So herein, क्या use होगा सोचो? Your globalization, NPM, CPA, public policy models. Okay, herein incremental model will be more used, right? And then you will have to draw in from international relations. You can take the example of the climate policy, right? Recently Guyanese Prime Minister spoke about it. India has been leading so many initiatives. G20, you had climate finance as one of the major aspects.
Comparison with some of the work, the policy in other countries with India.
With India, the whole comparative politics school is here. Okay, so things like that. So this was the trigger, you see, which actually 2020 this question, and these questions are largely in part B. Okay, so remember, if you are not very good at it, you can hedge your risk accordingly. These are largely, if it's a 15 marker or a 20 marker, it's 6, 7 or 8, or 10 marker, then you have no choice. You will have to do question number 1 and 5. Okay, next. Again, you see the abstractness of the questions are coming up. Policy problems are increasingly tending towards being wicked. Discuss the capacity and preparedness of the state to tackle these wicked problems. Now go home and write this answer. What are these wicked problems? ये मैं जानना चाहूँगा. So there is a head, evaluation, review and their limitations. It is related to that. Then, like I said, linking the stage with anything else. So 21, again a solid one question, but 20 marker. Something that you could have skirted by exercising other options. But usually you will see what will happen, that the UPSC in the compulsory bracket, if it is going to give this question very difficult, it will give this easy, relatively easy, I mean, not easy means easy. There is nothing called easy. Right. And in the other one, what they will do is, let us say in this one, okay, they will make this easy and this difficult and this moderate. See, the structuring of the paper is also plays with your psychology. So आसमान से गिरे और खजूर में अटके, एक तरफ कुआं एक तरफ खाई. So at times it might be unavoidable. So take a what should I say? Take a calculated risk. Okay. Next, again, you see 2022 policy evaluation contributes fundamentally to sound public governance. The question which was asked in 2020 was a negative idea, that it is promoting the status quo in political and social order, whereas this is a positive idea. The underlying concept remained the same. 2022 again, and again 2022 we saw that it is 40 marks again. One 10 marker, that was 5B, and then two 15 markers. Again invoking a thinker, Lindblom regarded rational decision making as an unattainable goal. In the light of the statement, suggest measures to avoid policy failures. So Lindblom follows incremental approach, right? So there are thinkers like, for example, David Easton, Robert House, Lindblom. You should remember these thinkers. Okay. Next question, 22 itself. Failure of public policy has often been attributed to problems of implementation, while implementators question the policy design. Discuss the contestation. So again, a part of the policy process, a stage, implementation stage. Then 2023 again 30 marks. Cost benefit analysis is of great help for policy makers in framing policies and providing advice on developing public policy. See, such a generic question. The question is seeming so generic. Okay. Next. So this one was compulsory, 10 marker. Next was, so one question, if it is going to give one question, the chances are that it will give a 10 marker. But if there is a more share allocated, then there will be second part B. Public policy making is an effort to apply the method of political analysis to policy area, but has concerns with the process inside the bureaucracy and stakeholders. Okay. So it is looking at bureaucracy and stakeholders. Now write down a question. Bureaucracy continues to remain an inalienable part of every stage of the policy process. Full stop. This aspect has both positive as well as negative effects. Discuss, full stop, discuss with recent examples or discuss with examples. Take this as a 20 marker. Okay. Take this as a 20 marker. ठीक है जी. Understood this aspect? Should I raise this? पब्लिक तो बाद में देखेंगे. What is policy? What is an unplanned approach then?
Unplanned means it happened based on circumstances or suddenly.
Then that would be a reaction, not an approach. कभी कभी एक एक वर्ड को डिफाइन करना ना इतना डिफिकल्ट हो जाता है बिकॉज देर आर काउंटर क्वेश्चंस एंड यू शुड एंटिसिपेट दोज काउंटर क्वेश्चंस बिकॉज द डेफिनेशंस कैन नॉट बी सब्जेक्टिव. द डेफिनेशंस विल हैव टू बी ऑब्जेक्टिव. ये भी हो सकता है और वो भी हो सकता है वाली बात नहीं हो सकती ना डेफिनेशंस में. एंड डेफिनेशंस इन माय ओपिनियन आर अंडररेटेड. बट व्हेन दे आर ऑब्जेक्टिव स्टेटमेंट्स, they convey you the exact meaning. Yes, we can have debate about the meaning, we can have debate about the definition itself, whether that is correctly defining or comprehensively defining a thing or not. Whenever you see a policy, policy को हिंदी में क्या बोलते हैं? नीति. A policy is what? It's a purposive course of action. It's something which has a purpose, a course, and action. Now, who will adopt a policy or who will act? Who will be the actor and who will be the receiver? Largely, a person who is in power will act, and a person who is disempowered will be a taker, not the initiator. So it's a purposive course of action by people in power to achieve certain goals and objectives. Now, if we add the word public to it, the moment we add the word public to it, that means we are adding public interest. And who exercise powers with respect to public interest? State or administration. And therefore, just like we have had multiple views on what is public administration, and all of them are looking at public administration, the scholars, from various lenses, similar is the case with public policy. If I can say that with the evolution of time and evolution of the discipline of public administration, the scope of public policy has become widened, right? What if I put a negative connotation and say that with time the scope of public policy has become vague? You will say, no, it is not vague, rather it has become too complex and interdisciplinary in nature. ठीक है? Also, whenever I link with public policy in the modern era, the things that public policy has to deal with are many than, let us say, it used to deal with in the past. But is public policy a new phenomena or an old phenomena? It's an old phenomena, practically as old as civilization. But the levels of sophistication, the levels of differentiation that it has acquired ever since public administration has become a separate discipline and increasingly goes on to acquire that. This is a new era. So, in the modern day, it is not just the action part of the government, but the action through policy by the government has become synonymous with public administration. So, that way you will incorporate the policy view of public administration as well. समझ में आई ये बात? कैसे लिखना है? ठीक है. Now multiple scholars have defined, and I want you to have those definitions for the simple reason that you can use that in exam. Okay. David Easton with regards to public policy says that the authoritative allocation of values for the whole society. The authoritative allocation of values for the whole society. The reasoning which he gives is that the authorities which are the part of a political system, they engage in the daily affairs of this politic system. Democ says with regards to policies that they are consciously acknowledged rules of conduct, consciously acknowledged rules of conduct. Why? Because they help guide administrative action or administrative decisions. Dror says that they are general directives on the main line of action to be followed. General directives on the main line of action to be followed. Peter Self says that they are changing directives as to how tasks should be interpreted and performed. Changing directives as to how tasks should be interpreted and performed. Now, very underrated definition which is by Brian Smith. You see, he defines policy as a deliberate course of action or inaction. A deliberate course of action or inaction taken by those in office, under the influence of values and pressures, on the way resources, expenditure and coercion are to be used in pursuit of objectives or in support of other policies. Also, answer me a question. Is public policy a means or an end? Means to an end, right? So, it is a course of action or a means or a pattern of activity. It is not a decision. This is something which is said by Richard Rose. Also, it is a means to an end. Also, it marks a relationship of a government unit to its environment. It marks a relationship. See, I don't know how many of you have visual thinking, but I have it. Okay. So, the moment you start visualizing the stuff, no, you will understand the stuff better. Now, there was this guy called Dye, not D-I-E, Dye, Thomas R. Dye. And he was saying that, oh my God, you are giving such complex definitions. And he says that public policy is whatever government chooses to do or not to do. Which is again just like Brian Smith, friends. It is very comprehensive yet very simple. Whereas the view of regarding environment, the means to an end, right, and the idea that it's a course of action or a pattern of activities and not a decision. These talk about the far more qualitative aspects of public policy. Okay. So, when we look at the space of public policy, it is as wide as the space of the government functioning. Okay? But it is a purposeful activity, therefore, it is goal oriented. A clear set of activities. Often, public policy is the vehicle Yes, service delivery can be there. It's a policy regarding, let us say, education, health, you can say service delivery. What is my policy as a nation when it comes to conflicts outside India? That is also a policy. That right now strategic autonomy is my policy. Right? My policy whether to negotiate with the terrorist or not is my security policy. So, that ways. Okay. Like I said, these public policies actually reveal the relationship of the government units to their political environment within an administrative system. Also, public policy is not just your education policy, health policy. It is manifested in laws, ordinances, court decisions, rules, regulations, etc. And it is always there to achieve a goal or to solve a problem. So, it has a similar sanctity like that of a law or authority. Public policies are the outcomes of the collective action of the government. Okay. So, while goals are ends, policies are means to those ends. Whereas, if we look at the concept of policies and decisions, they are similar in some sense, because in both it is about choosing from a set of alternatives. Okay. Now, if you look at public policy and administration, see, it is very important to get into the soul of these things, unless you will not be able to handle random questions. In the exam, the question is not going to be like this, but there can be a one-liner statement. Okay. So, public policy and administration. Now, let me take you back to Wilson. Wilson actually talked about dichotomy. That means separation of policy and administration. So, therefore, the Wilsonian vision was very rigid when it comes to the policy and the administration, because he was looking policy as a political function, okay, while the administration was only concerned with the implementation, wherein he says that the field of administration is a field of business and it should be removed from the hurry and strife of the politics, and therefore administration should lay outside the sphere of politics. Administrative questions are not political questions. Okay. So, the classical ideas that were flowing were largely built in and around the idea of dichotomy. Okay. And hence, the development of the discipline as it was progressing under the Wilsonian beacon was on these lines. So, the public policy development was going on one hand and the implementation science was going on the other hand. So, not just the politics and administration was separated, the policy and administration were also separated. And this thought dominated the Western view, particularly the American view, for a long time, till we see the coming up of Minobrook 1 or so, okay, for a very long time. It was beginning to get realized through somewhere that though both are different, rather the one single entity, the one single agency might be handling both, but both are different. A flexible distinction between the two was not possible, neither desirable. They said they will remain different no matter how closely they fall. Okay. You see, but in later part, Wilson was also somewhere, thinking on these lines that we should not take this argument too far, to the extent that it becomes impracticable. So, what happens? Piffner actually comes out and says that please guys, hang on, don't be obsessed with, such an idea of extrapolating this distinction to astronomical levels. He said that a clear distinction is difficult. And he said, interestingly, he said that the line of distinction between the policy and the administration cannot be a single line, but wearing shades of grey. I wish my drawing would have been better, but wearing shades of grey. From black to wearing shades of grey. Finally merging somewhere. While some of the purists were thinking that the executive function was to legislate. The function of the state was to legislate. That is, make the policy and leave the others to administration. So throughout the period after Wilson, the scholars, it is not something that Wilson said, decided, okay, nobody is thinking about it. The scholars, the academics, the universities, corporations were actually, churning the idea. They kept on churning the idea that whether they are different, whether there's dichotomous relationship, or the relationship is far more fusion oriented. So there were multiple theories ki haan itna nahi itna kar lo, let us keep it grey, etc. And there was this dynamic stability which was going on. Some people were actually thinking that the administration is encroaching into the policy zone. So till the time Gulick comes, Gulick makes a statement. Gulick says that politics cannot be taken out of the administration, nor administration can be taken out of politics. So this in a way marks the academic recognition of the beginning of the blurring of line. Right? So when we say that administration or bureaucracy is a part of the policy process, ठीक है? Soon after Democ, he comes up with an idea that actually the two processes are not exclusive, rather they coordinate. Then Frederick, not Fred Riggs, Frederick, says that it's a misleading distinction. And it has become a fetish of sorts for the scholars and practitioners. And then there were scholars to actually emphasize upon the correlation views like Appleby, Kingsley, etc. said that nothing but administration is a branch of politics. Waldo says that the separation between the two has become an outworn credo. Waldo. So Waldo, as we know, Minobrook won the champion of the NPA era. So you see how the transition is happening. Okay. So this was largely the American view which was happening in the public policy space. Now, in Britain, on the other hand, because you see, Britain was one of the colonial powers, and at that time you did not have the mobile phones or the internet or the WhatsApp or emails. So it would have taken months to actually transmit the orders or the policy function. So there the incorporation of the civil services, because the monarchy, the civil service, the elite of the society and the colonists were largely belonging to a homogeneous mix of people. So in Britain, on the other hand, the role of administration in policy matters was long recognized. It was the administrative class which was seen with the formulation of policy. That is why you see the strong notion of civil service that exists in Britain and in ex-colonies. For example, India, you cannot find a similar thing in, let us say, US. US, you would, okay, there would be some Lou or, you know, some person of assistant secretary of state, but it is the the secretary of state which, you know. Yes, the ruled was sitting. So it was necessitated by the fact that, one, two, the own nature of the British administration within the British Isles, which were approachable, where orders could flow. Also, you will have to understand that it was a monarchy, right? So you had a government and democratization after Henry happens, and it gradually takes shape. Then the administration becomes focused. For example, Robert Peel set up the first modern metropolitan policing system in London. Robert Peel was a prime minister, later became one of the first prime ministers under Queen Victoria, right? So the point is that there, the nature of politics and administration was premised upon civil service, and you will find many Britishers, thinkers, scholars quoting the relevance of civil services for the British, governance overall. Okay, so the point is that this idea was recognized, and the civil service or the bureaucracy or the administration was being seen as a legitimate part of the formulation of policy. Okay. So, to that extent we can say that the administration which was there, it did not only deal with the means and methods, but also it determines the ends and the values. And administrators at all levels are called upon to make decisions, and these decisions actually end up to the policy or the politics level in the subsequent course of events. That is why you see thinkers like Appleby put administration as a sub-school of politics. Because it is these administrators that are laying the rules for the future administration and future course of action. This is a view of Appleby. Right. Also, if you will see at the formulation level, you will have to understand that the policy process might have certain stages. While this is an orderly arrangement, I am not talking about which order, this order, or you can draw it like this also, that is fine. Also, the bureaucracy as a hierarchical institution, the various stages of the administration will be involved at various stages. No one is saying that entire administration is involved at every stage. No, differing parts at different times, but a constant interface with administration gets maintained. Okay. So, like I said, with regards to Britain, it was something which was there. Okay. Because now getting into the Pabadish mode after understanding, they supply the facts, information, data, criticism, feedback. Because the ministers, the legislators, the public representatives, they don't have the talent for all these things, neither the expertise. It is the administration which is in constant touch with the general public. Also the initiative comes from the administration. Also take a leaf from delegated legislation. It only passes the skeletal legislation. The details are filled by the administration. Though, as MP Sharma says, Professor MP Sharma, there is a book by MP Sharma as well of public administration, good book. Okay, that the administrative policy is largely concerned with the determination and establishment of appropriate machinery and procedure for implementation of legislative policy. All right. So, with this thought, I want to leave you all today with an idea to reflect on the interconnections. I deliberately wanted to go into this whirlwind journey because it is very easy for me that I can talk about incrementalism, rationalism, differences between the two. But to actually look and relate things, link history, your existing knowledge with it, and how to specifically come about with some points. Right. So before we actually call it a class, any doubts whatsoever? Any doubts? Deciding what policy, what, how, why, and the details. Administrative input is the key input. Mr. Modi will never know what things are happening on the ground unless administration tells him. Also, who keeps these records? Administration. Who's at the forefront? Administration. Who's responding to the queries? Administration. Implementation based on the environment, that is the implementation part. We are now looking at just the policy as an idea. So that is the key contribution of the administration. Even the dichotomists were saying that administration is for implementation. So nobody is doubting that administration is not for implementation. What we are doubting, or what there were views were, that whether the politics and administration are dichotomous or harmonious or interrelated. That is the question that we are dealing with. So, in that sense, the administration sometimes become the cause for the initiation of the policy. Then how can it be dichotomous? Right? Data, facts, information, daily interface. Okay, so that is the reason. Alright, let's call it a class and thank you. Thank you everyone.